Consider the landmark case of Anwar PV versus PK Bashir and others in India. This case revolved around a land dispute, where the primary evidence was a compact disc containing a conversation between the parties involved. However, the Supreme Court of India ruled that the compact disc was not admissible as evidence. Why, you ask? The court found that the electronic evidence failed to meet the requirements of Section 65B of the Indian Evidence Act, which mandates a certificate from a person occupying a responsible official position regarding the secure storage of the electronic record. Without this certificate, the court deemed the compact disc as inadmissible, and the case took a dramatic turn. Now you might be thinking, well, that's India, but what about other jurisdictions? The truth is, many jurisdictions around the world have similar requirements for the admissibility of electronic evidence. For instance, in the United States, the federal rules of evidence require that electronic evidence be authenticated, relevant, and not hearsay, unless it falls under a hearsay exception. That means an email or text message must be proven to be what it purports to be, must be pertinent to the case at hand, and must not be used to prove the truth of the matter asserted in the message. So, what does all of this mean for the validity of electronic evidence? It underscores the importance of understanding the legal requirements for electronic evidence in your jurisdiction. Whether you're a lawyer, a law student, or just a curious mind, it's crucial to know that the admissibility of electronic evidence isn't a simple yes or no. It's a complex issue that depends on various factors, including the nature of the evidence, the method of its collection, and the laws of the land. To sum it up, electronic evidence can indeed play a pivotal role in legal proceedings. However, it must meet certain legal standards to be admissible in court, as demonstrated by the case of Anwar PV versus PK Bashir and others. And while the rules may vary across jurisdictions, the underlying principle remains constant. Electronic evidence, like any other type of evidence, must be reliable and trustworthy to be considered valid. So, the next time you hit send on that email or text message, remember, it could potentially become a piece of evidence in a court of law. But whether it would stand up to legal scrutiny, well, that's a different story altogether.